Open. All who have business before this court are all here. Give attention, you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. I would like to first of all welcome and thank Judge Wendy Berger. She is a circuit judge in St. Augustine and has kindly agreed to sit with us today and tomorrow because, as you all probably know, we are one judge short, and this way we were able to have a full three-judge panel this week. So, Judge Berger, welcome and thank you.
You're welcome.
I'm sure counsel have all been explained how the clock works and understand. If you will, nevertheless, if appellant will note the rebuttal time they want, I will try to undertake to assist without interruption. The first case on the docket is Larner versus State of Florida Department of Management Services. Mr. Irvin.
May it please the court. I'm here on behalf of the appellant. This appeal relates to the appellant's application and denial of in-line disability retirement benefits. If I could, I would like to reserve 5 minutes of my time for rebuttal. This case arose relating to an incident that occurred at the Hardy County Jail on December 28, 2001. Appellant Mark Larner was employed as a corrections officer with the Hardy County Jail, and during a routine search of an inmate, the inmate suddenly bolted, and claimant who had brought with him to the employment several pre-existing conditions which remained asymptomatic during the year, approximately 15 months employment period prior to the time of the incident. He had worked without any disability.
Counsel, could I ask you a question?
Yes.
As to whether or not your client was permanently and totally disabled at the time he terminated from employment.
Was he?
Isn't this court bound by the facts as determined by the commission?
No, ma'am. Not if there is not competent substantial evidence in the record.
Wasn't there conflicting evidence, though?
Was there conflicting evidence?
Mm-hmm.
I would say no, and the reason I would say no is that, as a matter of law, the commission found that the claimant was asked to resign as a result of the disabling condition. This court in the Maudlin, Mauldin case, said on facts that were very, very similar to this, that where an applicant is forced to resign from employment, that such action does not comply with the definition of permanent total disability. And that statute is set out in the commission's order at page 6, wherein that's section 121.0914B.
Mm-hmm.
That's defined. Total and permanent disability is defined as a member shall be considered totally and permanently disabled if he or she is prevented by reason of a medically determinable physical or mental impairment from rendering useful and efficient service as an officer or employee. Now, the critical words as I read this particular statute are the terms officer or employee. In this particular case, I don't think there is any question that the claimant met the first test, which that he complied with the statutory definition of disability in line of duty set out in section 121.02113, which provides disability in line of duty means an injury or illness arising out of in the actual performance of duty required by a member's employment during his or her regularly scheduled working hours.
But the commission did not address whether or not the appellant was totally and permanently disabled, unable to render useful and efficient service.
In all fairness, Your Honor, I think that the Commission's order is somewhat conflicting and inconsistent in that regard. It appears to me that in one place they said we do not reach the issue of the claimant's permanent total disabled status because it apparently felt that he had not met the test of the causation test required by the definition for disability in line of duty, that is, the arising out of test. However, in another portion of the order, at page 5, the Commission says, at present, now remember, when the Commission wrote this order, this was March of 2009, 7 years after the work-related accident, and 4 years after the claimant had been forced to retire. It says, at present, it appears that petitioner is not able to work, but the Commission cannot merely grant total and permanent disability. Most of his conditions are the result of aging, possible prior accidents, and a botched surgery. The Commission finds no in-line of duty accident was a contributing cause to Mr. Larner's condition.
But hypothetically, counsel, if we agree with you that no competent substantial evidence supports the finding that an on-job injury was the cause of the appellant's condition, should we send it back for further findings with respect to whether he's unable to perform his duties as an officer or
Certainly
employee?
that's an option, Your Honor, and as I said in my initial brief, it seems to me that the Court has that particular option. I would say that the preferred option under the circumstances, because there was clearly, first of all, there was clearly no competent substantial evidence supporting the Commission's determination of the lack of the causation element. Dr. Patel, all of the medical providers, three of the four medical providers clearly related the work contribution as the cause of the claimant's resulting disability. The only one who did not relate it was Dr. Lonstein, and he did not. All he said was that his testimony was simply causation neutral. He didn't say that there was either an occupational cause or a non-occupational cause. Now, what I'm trying to say is, I agree that the critical issue, as I see it, is whether the Commission was correct in making a determination, as I think clearly either they made that determination or they didn't. The order is patently inconsistent. If the order can be considered as saying that we don't reach the issue of the claimant's permanent total disabled status, then I suggest to you that by reason of the fact that the claimant's testimony was unrefuted, that he was forced to resign his employment, and therefore, under the circumstances, that is the Malden case, which I have cited in the brief extensively, which seems to suggest that when there is no employment available within the claimant's former employment, and it simply does not matter whether or not the claimant, as there was indeed testimony that claimant could find work elsewhere. But no one, that is the physical therapist, Sonal Nunez, who conducted a functional capacity evaluation of the claimant. She said while he was capable of work, she didn't identify any work within the Hardee County jail, that is the place of his former employment. That to me simply does not consistent, as this court indicated in Malden, with the test of permanent total disability. That is, that the claimant be prevented by reason of a medically determinable physical or mental impairment from rendering useful and efficient service as an employee, as an officer or employee.
Wasn't Mr. Larner doing sedentary work at the time he terminated employment? Wasn't he doing the video monitoring?
No, he came back in April, I believe, of 2002, approximately 4 months after the work-related incident. Worked there for approximately 4 weeks and then left. When he was asked to resign, which was January of 2005, he had been taken off work. He'd been off work for about 1.5 years by his attending physician, Dr. Patel.
Okay.
So
monitoring the video is sedentary work.
That's sedentary work, clearly sedentary.
And didn't Ms. Nunez and somebody else, but certainly Ms. Nunez, in her functional capacity test, didn't she find that he could engage in sedentary work?
In sedentary work, that's correct. But the point is that in January, he was told by the employer that there was no position available for him. He was asked, his testimony was that he was forced to resign. So,
Counsel, you're into your rebuttal time.
all right, thank you, Your Honor. I suggest to you that this case is controlled by the Malden rule, and that while the court clearly has the option of sending this case back for further findings, I really don't think it's necessary in view of the particular facts here. That fact being primarily that the claimant was forced to retire.
Thank you, Your Honor.
Counsel,
Sir.
As I read your brief, the appellee argues that neither Dr. Patel or Dr. McClymonds opined with respect to whether the job injury was the producing cause of the appellant's condition. But as I read their reports and Dr. McClymonds' deposition, it seems to me that both of them say that the disability was due to the on-the-job injury.
Yes, sir. However, both of them also rely solely on the claimant's version of the injury. There was no, Dr. Patel did not find any evidence of a physical injury. He found a pre-existing condition, the PARS, which he said was years old, long before this injury occurred. While he said it could be aggravated, his diagnosis was still based, and the causation was still based on the self-report. The claimant did testify. His credibility is an issue. As this court found in Veely, if a medical opinion is based solely on self-report and the self-report is not deemed credible, which is the commission's job, is to determine the credibility of this witness, then they are free to disregard the medical evidence. And I believe that's what they did here. Did
any medical witness testify that the condition of the appellant was not caused or aggravated by the on-job injury? Did anybody address the negative, as
No,
we
sir.
often see in workers' comp cases, as you know?
No, sir. No, sir. I don't believe anybody did. I don't believe that's in the record. As for
So the only evidence with respect to the issue is that there was a causal connection which the commission rejects because that testimony by the doctors was based on the self-report by the appellant.
Yes, sir. And again, no physical evidence to support the injury at that time. Dr. Patel, he found the pre-existing condition. He didn't find a new evidence other than the report of pain.
But there was a report of the injury at the time it occurred.
Yes, sir. Yes, sir. I'm not denying that at all. There was. He did bring it to the employer's attention like he should have under work comp law. But a lot of the reliance of appellant is on work comp law, which this court has also found in Miller v. Division of Retirement, which is found at 796 Southern 2nd 644, specifically that work comp law is inapplicable to state retirement commission cases. As for the appellant's position on the commission finding that he was unable to work at the time of hearing, that's irrelevant. The statute specifically provides that they have to be totally and permanently disabled at the time they leave covered employment, not at some later date for hearing. As to the
What work did he do after that injury?
my understanding is he did some video surveillance, as you pointed out, at the Hillsborough County Jail.
And how long did he do that?
I believe several months. I'm not sure the exact time span, but I believe it was a couple of 3 months.
But again, doesn't permanent and total disability mean inability to work as an officer?
Not as a corrections officer, as an officer employee in the system. The system has 800 or 600,000 active members. Virtually every job imaginable is covered under the Florida retirement system. And the statute, as the cases have held consistently, does not require inability to do that function that he was doing before. It's the inability to do any job in the system for any employer. It doesn't have to be for the same employer.
Are there jobs, sedentary jobs within the system?
Oh, yes, ma'am. Receptionist at my office, for one. I mean, there are plenty, and I believe most of you have probably been in state buildings where you meet receptionists and that kind of thing, that's basically all they do is greet the public. There's any number of sedentary jobs that have been identified in prior hearings. And again, that's what the statute requires, as the cases have interpreted, is any employer, any employment, not just the employer or employment that was in when he became allegedly disabled. And I believe that is all that I have. I'd be happy to try to answer any more questions.
I'm trying to refresh my memory, but do I recall correctly that the appellant was terminated and that there was told that there wasn't a position available for him? Is that correct?
That's what his testimony was. There was no other evidence to support that. That was only come from his testimony. And again, he testified before the commission, and his credibility is an issue and was judged by the commission.
What is the evidence that there were jobs available that were offered to him?
Again, the statute does not require that they be offered to him. It simply requires that he be able to perform them. And that's what the cases have consistently held.
So under the case law, if no job is available, but yet he was capable of performing this unavailable job, he cannot be permanently and totally disabled.
Yes, sir. That's what the case law says. And, there's no evidence that he ever sought employment anywhere else, any other kind of position other than the jail where he was working.
Okay.
Thank you, Your Honor.
First of all, I would simply point out that during the rather brief period of time that the claimant returned to work for the former employer, the Hardy County Jail, the commission specifically found that several weeks' employment was sheltered employment, clearly, which supported the determination, had it made it, that he was indeed permanently, totally disabled, because sheltered employment is not efficient service as an officer or employee of the Hardy County Jail system. My reading of the Malden case, insofar as the duty of the claimant is, that once he is forced to resign, that and he is told there are no positions available within that particular system, that he has satisfied his burden. That's my understanding of the Malden case, that if he is told by the former employer that because of his physical condition he simply cannot work, then he, for all practical purposes, is permanently, totally disabled, and he meets the statutory test.
Is that regardless of whether or not there may be some other employment at some other agency that he could do?
My reading of the Malden case is that there is some kind of affirmative duty on the employer to assist the claimant in that regard. Now, it's been some time since I've read Malden, but I believe that once they decline to take the claimant back, there must be some type of responsibility on its part to assist him within the system, that is. And nothing was done. And the reason it wasn't done in this particular case was that he left the employment as a part of, according to his testimony, which was unrefuted, as part of a workers' compensation settlement. So he was drawing, apparently, although the record is not clear on that, he was drawing a permanent total disability benefits through the workers' compensation system. Having said that, it would appear to me that, and given the finding that the brief reemployment by the claimant was sheltered, it would appear to me that there simply was no work that he could indeed do, even in a sedentary capacity, for the former employer.
Counsel, the appellee has argued, if I understand correctly, that even if there are no positions available with the employer, that if the claimant is capable of rendering service in some capacity, even though no position is available, that nevertheless the claimant cannot be found totally and permanently disabled.
I would suggest to you the findings of the commission militate against a finding that he indeed had the ability to perform some type of employment, because it did say that his work, even in a sedentary capacity, was sheltered. As this court well knows, sheltered is a technical term that means simply that the claimant is, for all practical purposes, permanently, totally disabled, and the employer is simply giving this particular employee a position, perhaps to avoid workers' compensation benefits. But I suggest to the court that a careful reading of the Malden decision, wherein a claimant is forced to retire, as this particular claimant was, strongly intimates that the claimant was in fact permanently, totally disabled. And I would suggest to the court a reading of the findings by the commission itself suggests that by the fact that they said at present, 7 years after the claimant's work-related incident, it said at present he is unable to work.
Counsel, your time is expired.
Thank you very much.